afternoon, everyone. Welcome to our latest employment law and HR update. This is the first one since April, so one of our quarterly sessions. If you've missed any of our previous updates, then please go through to our YouTube channel, because on there you can catch up with all of the other updates that we've published in the past few months. And in fact, even before that, because I think the content on that YouTube channel goes back now to approximately 2 years worth. So please do check that out. And welcome to today's update. So what I'm going to do is I'm going to talk through a number of key things that have been happening. And I've got to say that actually there is an awful lot of content that we've got to get through this morning. So I'm going to try to make sure that I cram it all into the hour session today. I say try to, I will do. And because I'm not going to overrun it anyway, because I know that that's what everyone hates, because we've probably all got calls booked in at 1 o'clock in any event. So without any further ado, I hope that you're all settled down with a nice cup of coffee or cup of tea, or probably in this warm weather, something a little bit more refreshing than that. So we're going to look through legislation, we're going to have a look at what's on the horizon, and we're going to have a look at the latest case law that's been coming out of the courts over the last few months. So first of all, the Queen's speech. Well, what's the relevance of this? Well, not a huge amount. It was really the fact that there wasn't anything in the Queen's speech that related to employment that was the most surprising thing. We were expecting a number of announcements to come out. As you can see, we were expecting something in relation to fire and rehire. We were led to believe that there might be some steps that were taken by the government in order to address the trend that we've seen, particularly through the pandemic, of employers such as Tesco, such as British Gas, who have been going through major fire and rehire processes. I'm going to address that a little bit later, because we've got a couple of cases on fire and rehire, which I'm going to talk about. We were also expecting some proposals in relation to neonatal care. So obviously in situations where effectively the parents of children lose out on the benefit of maternity leave or shared parental leave to an extent, because for a period of time that their newborn child is in hospital, and so they're not getting the opportunity to spend as much time with their newborn child at home and caring for them in that way. And so there is a consultation that's been out, and so we were expecting some legislation in that regard to try to balance off the lost time that people have in maternity and shared parental leave as a result of neonatal care. But again, hasn't happened. Now, whether, of course, it will in the future, the consultation is still there, and so we are expecting something to happen in due course, but quite frankly, when that might be, we don't know. We were also expecting something in relation to carers' leave. Now, this would be unpaid leave, and doesn't negate the fact that, of course, people have already got entitlements under the time off for dependents leave, to take time off for what is generally regarded as emergency leave. What the carers' leave was going to do is it was going to allow people to take unpaid leave for non-emergencies. So just helping people out with their meals, perhaps their financial planning or things like that. And then finally, the one that we were really expecting, the others we were just quite expecting, the one that we were really expecting was the extension of the redundancy protection for women returning from maternity leave. Now, just to give you a little bit more information on that proposal, and I will just make that nice and big so that you can see it properly. Now, this is all to do with a proposal that was made back in 2019. Now, just to give you the background of what the current protection is. So if a woman is on maternity leave and she is then at risk of redundancy and is facing redundancy, there is an obligation on an employer to provide that employee on maternity leave with any suitable alternative vacancy that exists and prioritize her over any other employee. So essentially, if a suitable alternative vacancy exists, even if she's not the best candidate for the job, then she gets offered the job because of the protection that is afforded to her because she's on maternity leave. Now, the proposal that was made by Theresa May's government in 2019, as you can see in the Queen's speech in 2019, was that this would be extended for a period of 6 months after her return to work. This still hasn't happened, and there is no commitment from the government as to the timeframe. As you can see, they've provided a fairly loose and woody response when pressed on the matter, and they've just simply said they will introduce it when parliamentary time allows. Now, of course, yes, parliamentary time has been, I would imagine, somewhat pressed over the past 15, 16, 17 months as a result of the COVID pandemic, of course, but it'll be interesting to see quite what the timescale is going to be, but we will wait that with bated breath. Now, you'll see there's a bit of a theme that begins to run through here, because then we turn to ethnicity pay reporting. Now, this is essentially a similar scheme that deals with ethnicity pay reporting in the same way that we already deal with gender pay reporting. And as you can see here, a little bit of a timeline again. So first of all, in October 2018, actually that's 2018, so October 2018 and January 2019, the government conducted a consultation on proposals for a mandatory approach to ethnicity pay reporting. Then there was no response to the government from that as a result of that consultation. There was then a private members bill that was then introduced in 2019 in January 2020, that was to try to push the government along in this regard because of the silence from them following the end of the consultation. And then in June 2020, there was an online petition to require a parliamentary debate about it. And so you can see that there is a lot of effort that's being put into trying to press the government on this point to introduce the legislation. And the thing that has then happened in the past few weeks is that there has been a joint letter from the CBI, the TUC, and the Equalities and Human Rights Commission, specifically asking the government now to introduce ethnicity pay gap reporting. Now, when we go back to the consultation itself, now it's been reported, it was reported by the BBC, in fact, that that there were over 300 responses to this consultation document. And in that consultation document of employers, there was an overwhelming response to support the introduction of ethnicity pay reporting, to the extent that 73% of all of those employers that responded supported the introduction of this scheme. There was a bit of a mixed view in terms of whether that should be pay reporting or pay comparison in relation to white employee and all other groups, or whether there should be a breakdown by ethnic group. But simply put, I mean, again, I'm sure this is something that is going to happen. It is bound to happen, and particularly with the latest issues in relation to race relations and that we've seen as a result of the Euro 2020 final. I mean, it is bound to be something that is going to be introduced, but we're just simply going to have to wait until the government actually legislates for it. But it's prepare yourself for it. As an employer, we should be preparing ourselves for this now. And a number of employers, larger employers, are actually beginning to take the lead now as well themselves, and are beginning to voluntarily publish this data. Continuing the potential discriminatory theme, as you can see from this article that I'm sharing from The Guardian, is that there has been an impact obviously with COVID and with all of the home working activities, and particularly, I mean, I've seen it with a number of clients that I deal with where female employees who are working from home and taking putting it bluntly, the brunt of the childcare responsibility, and then trying to balance that childcare responsibility with their activities of working from home. And so we've got this situation where, in fact, whilst it might appear that there is this greater flexibility that employers are giving, that there is still an inherent potentially sex discriminatory aspect of working from home. And as part of the attempt to try to reduce the impact of this, there is a case which I'm going to be talking about a little bit later on, which is the Dobson case, which talks about the inherent impact that childcare has on female employees and how female employees are generally still at a disadvantage as a result of the having to take the brunt of the childcare responsibility. But in terms of trying to actually encourage employers to take a proactive approach to having a more flexible workplace, of course, lots of employers are now moving to hybrid working. Not all, and I'm not saying for a moment that employers have to move to a hybrid working, but a lot are seeing the benefits of that. But what particular MPs and groups are now doing is they're trying to encourage the government to actually provide financial incentives to provide even greater flexibility. And as you can see with this one, it's about introducing in financial incentives to encourage employers to look at job sharing, to introducing job sharing. Now, again, I'll address the job sharing issue a little bit because, of course, job sharing is something that we're often, as employers, faced with when employees are wanting to perhaps think about working part-time, particularly after having had children. And that's where we see the peak of flexible working applications. And of course, job sharing is a key solution to those job sharing applications. And so it's going to be interesting to see whether this is something that the government is going to have a look at. It certainly seems like a pretty sensible way of at least trying to remove some of the financial burden that employers see that there is with job sharing, because of course you're always having to have sort of crossovers and handovers, and so that inherently creates a cost, because then there is going to be a situation where you're going to have two people undertaking the same job. So it not always, but it often adds in an additional cost as a result of job sharing. So what this scheme is trying to do, what this suggestion is trying to do, is trying to look at ways of which that can be incentivized, and so removing those barriers for employers. So it'd be interesting to see whether that gains any traction. But of course, that initiative is still some way behind the ethnicity pay gap reporting. It's still some way behind the redundancy protection for mothers returning from work, which have already gone through consultations, and you can see the delays that we're experiencing in the introduction of those. So don't hold your breath, but hey, you never know. Let's see what happens. We'll obviously keep you updated on what happens on that front. Now of course, the issue of legal working has changed somewhat, particularly as of the 30th of June, because as of the 30th of June, of course, any of your employees that were or that are EU nationals should have now completed their pre-settled status or their settled status applications. And so now, as we are bringing in, if we are bringing in employees from overseas, from what still remains the EU, but of course we're not being part of the EU, we've now got to undertake all of those additional checks for those individuals that weren't in the country by the end of the year in 2020. So in order to address that, the Home Office has reissued their code of practice on preventing illegal working. And what this code of practice does is it includes an updated list of documents. For those of you who are familiar with the checks that you have to undertake, and I would hope that you all are, because of course we should be undertaking these checks for every single employee that we have. So they've updated lists A and lists B, which detail the documents that you need to check if you're not utilizing the electronic service. And essentially what that means is that those documents in list A, they of course provide for a continuous statutory excuse. And what I mean by that is that if it's then later discovered that that person is in fact working in the UK illegally, if you have undertaken those checks and you have copies of those documents, and there's no reason for you to disbelieve the authenticity of those documents, then that means that you will not be fined for employing an illegal worker because you have that statutory excuse. Those documents in List B provide for a time-limited statutory excuse. Now, in terms of the fines that can be levied on employers, now they are fairly serious, and essentially what, just to give you a very brief overview on the level of fines. So if you have found to be employing illegal workers in the previous 3 years, as well as on the occasion when you are then caught, then, sorry, you have not been found, correction, if you've not been found to be employing illegal workers in the previous 3 years, at the point where you have been found that you're employing illegal workers, then there is a civil penalty of £15,000 per illegal worker. If you have been found to be employing illegal workers within the previous 3 years, the starting point for the civil penalty is £20,000 per illegal worker. So as you can see here, the issue of illegal workers is really very serious in terms of the potential liability for you. So it's very important that you follow the code of practice, that you comply with your obligations as an employer to undertake the checks that you need to ensure that you are not employing illegal workers, or at the very least that you're undertaking the appropriate checks to avoid the possibility of doing so. So, right, now we get into a bit of a COVID-19 section, because there are a few bits and pieces that I need to update you in relation to that. So, first of all, there is going to be legislation to make it mandatory for anyone working in care homes to be vaccinated against the COVID-19 condition. So an amendment is going to be made to the Health and Social Care Act of 2008, Regulations 2014. Once that is done, there is then going to be a 16-week grace period for care homes to implement this, which of course means that it gives us 16 weeks to ensure that our employees are actually vaccinated. As you can see from the final point there, we are awaiting an implementation date, so it's not quite clear exactly when this is going to come in, but obviously for anyone that is involved in the management of care homes, then you will need to be keeping an eye on this, and obviously we will again keep you updated on the developments in due course. Now, we are currently on the 14th of July. We are 5 days away from the 19th of July, which of course is only relevant in England. So the current work from home guidance will cease on the 19th of July. So for employers in England, from the 19th of July, you can freely welcome your employees back to the office. Now, I understand that in Wales an announcement is being made today, and I think it might actually be made as I'm speaking at the moment. So, so it might be that Wales is going to fall into line with England on that date, or it might be that it's a later date, or it might be that no announcement is made at this point in relation to it. So the work from home guidance still remains for Wales, as far as I'm aware at the moment. Check the website after the end of this update and see what the First Minister for Wales has said. The temporary adjustments to the right to work checks, so those checks that you're undertaking in respect of illegal working, which I was just been talking about, there has been an amendment to the rules in relation to that, because previously you had to see the physical document. Now, of course, that hasn't necessarily been possible as a result of COVID and all of the social distancing requirements. And so electronic documents have been photocopies or pictures, or being shown them over Zoom or Teams or something like that has been generally acceptable. But that is going to end at the end of August, because of course with the removal of all the restrictions in relation to COVID as of the 19th of July, then we can go back to requiring the physical checks of the documents. Now, of course, whether this changes in the future, we'll have to wait and see quite what the impact of the increase in cases, the inevitable increase in cases, is going to be. There is also a toolkit, essentially a communication toolkit that the government has published. They have published this in connection with the vaccination program, essentially to promote the vaccination program, so encouraging employees to get vaccinated. This toolkit, which is free to download, and when I send this, by the way, when I send this pack of information out to you all, then all of the relevant links will be included in the pack. So to hopefully save you having to Google and navigate your way around the government website. But that toolkit is going to come with various webinars, various posters, screensavers, scripts for conversations to have with employees, essentially just to encourage them. Now, on our YouTube channel, there is actually an update from a few months ago about whether you can force your employees to get the COVID vaccination or not. As you can see here, really, essentially the general rule is not. So unless somebody is working in a care home, where of course there's going to be legislation that requires those individuals working in the care home to have the vaccination, this is really a hearts and minds exercise. So it's about trying to encourage your employees to get the vaccination, because of course that's going to be better for, well, hopefully that will be better for their health in the long run. It will ensure that they avoid getting the COVID infection, and of course that then avoids the whole test and trace issue, because I'm sure that as we've seen an increase in the cases over recent months, that the number of employees that are getting pinged by the test and trace NHS app has been increasing quite significantly, and I know that a number of employers have been struggling with that in recent weeks. Continuing the COVID theme, so long COVID. So this is the knock-on effect, obviously, the long-term health effects that a number of individuals are experiencing as a result of having caught COVID in the first place. Now, the Office for National Statistics has estimated that more than 1 million people in Britain have suffered or are suffering from what is being referred to as post-COVID syndrome, or commonly known as long COVID. So NICE, the National Institute for Health and Care Excellence, has defined post-COVID syndrome as signs and symptoms that develop during or after an infection consistent with the COVID-19 and continue for more than 12 weeks and aren't explained by an alternative diagnosis. Now, what ACAS has suggested, they've essentially taken the position which is for employers to treat long COVID essentially like any other illness. So that is to get occupational health advice, see what adjustments need to be made, and be flexible in responding to the health difficulties that perhaps somebody is experiencing as a result of it. Now, as you can see from this slide, now the TUC have gone a little bit further. What they have done is they've written to the government, and they have asked the government to specifically identify long COVID to be recognised as a disability in its own right. Now, that would be, in my view, that would be quite extraordinary if they did, because there are a very limited number of conditions which are specifically identified as being a disability without having to necessarily substantiate the remaining part of the test in relation to disability, which is that it's got to be a long-term condition which has a substantial adverse effect on your ability to carry out day-to-day activities. Now, the issue here is that there is still much debate in, of course, and unsurprisingly, in medical circles about the causes of long COVID, as well as the prognosis of long COVID. And so essentially what we're saying is that a supportive and prudent employer will essentially err on the side of caution, and it will look to make adjustments for reasonable adjustments for its employees. And by doing so, then of course, we're effectively addressing the issue of disability by making those reasonable adjustments in the first place. But get occupational health advice, and essentially just act as a reasonable employer, and take the conditions that are the symptoms and the medical, essentially the physical and mental experience that somebody is experiencing as a result of having had COVID and the long-term effect that that might be having on them. Of course, this is a developing area, so we just simply don't have a huge amount of information. And of course, occupational health may therefore also begin to struggle on occasions in relation to being able to be able to give clear and certain advice in this area. So it's an uncertainty that we're going to have to deal with. I don't expect the government to respond to the TUC's call for long COVID to be identified as a disability. But as you can see at the bottom of this slide, we've got over 50% of people in the survey who say that they've been experiencing long COVID symptoms as experiencing discrimination as a result. So we've got to be careful in that area, because of course it could be a disability, and therefore if it is a disability, we've got to ensure that we're not discriminating against people as a result of it. But a developing area, of course. And continuing the COVID theme, but the final point on COVID, I've got a COVID case coming up as well that we're going to be talking about in the case update. But the TUC has also written to the government. So the TUC have been very busy lately, because we've got the letter to the government in conjunction with the CBI and the EHRC in relation to ethnicity pay reporting. We've got the letter to the government in relation to long COVID as a disability. They've also written to the government in respect of health and safety matters and everyone returning to work. So of course this goes back to the date of the 19th of July for those of us in England. Keep you posted on the Welsh issue, of course, the Welsh date. But as everyone returns to work, what the TUC are saying is that, well, actually there isn't a lot of guidance that's being provided to employers to ensure that everyone comes back to work in a safe way, because it appears that essentially, because of the rules that are now no longer going to be in place, that there's not going to be any requirement any legal requirement to wear a face mask at work, and so there is the possibility that those individuals who are immune suppressed, pregnant, or unvaccinated workers, which of course is the younger proportion of the population at work, are therefore going to be at risk. And so it's about protecting the health and safety of those people at work. Now, of course, while there is not going to be a legal obligation from the 19th of July in England to wear a face mask at work, you may have seen reported in the press that the London Underground, in fact, London Transport generally, has come out and said, if you're using any of our services, you will continue to be required to wear a mask. Now, employers, of course, can do the same. So if an employer wants to maintain the mask wearing rules at work, perfectly entitled to do so. It would be there's a perfect logic behind it. You're protecting employees. Essentially, you do your risk assessments, and that is the conclusion that you come to. And so, despite the fact that the legislation in relation to the requirements to wear masks might be lifted in England on the 19th of July, that doesn't mean that you as employers have to actually do the same. Okay, so it's something for you to have a think about. Appreciate there's only 5 days left for those of us in England to consider that. But of course, that's one of the reasons why the TUC have written this letter, because there was an awful lot of guidance that was being published by the government around May, June of last year, when we were having the original return to work. But there has been an obvious absence of information this time around. So halfway point. So now we're going to start talking about cases. And so what is on the horizon? Now, this is a slide that I always put up. So just to have a look at what cases are going to be heard by the courts in the coming months, and particularly the important cases. Now, I do actually have some news on some of these. Now, the Costal and Dunkley case. Now, this is only relevant to those of you who have trade unions and collective bargaining. And if you've got trade unions and collective bargaining, this is going to be a key case, because it essentially determines to what extent you have to ensure that the trade union agrees to the proposal. In this case, it was a pay rise proposal, or whether you can actually go out individually to people and give them the pay rise. This has been heard. We are awaiting the judgment. It hasn't been published yet, so it's going to be interesting to see what the outcome of that is. Obviously, we will cover that on a forthcoming update when it's out. Now, these next two, so the Flowers case and the Agnew case, these were all to do with holiday pay. Now, of course, holiday pay is an issue which has been rumbling on for, I think it's probably about 4 or 5 years now. Obviously, all derived from the original Bear Scotland case, and this is the requirement for companies to provide their employees with their normal pay when they are on holiday. Now, the Flowers case was going to address the specific issue of voluntary overtime, and as you can see, that is no longer going ahead. I say no longer going ahead. It was due to be heard on the 22nd of June. It was removed from the list. It didn't go ahead on the 22nd of June, and we believe that that was because settlement discussions were taking place, or in fact the settlement had been reached. And the same was true also of the Agnew case. So this was dealing with the 3-month gap. So where essentially the government introduced this issue about the fact that if there was more than a 3-month gap between deductions in wages, then that broke the chain, meaning that then the claim couldn't go back any further. This case was challenging that. And again, you can see this was removed from the list and it was settled. So we don't get answers to those questions. So when I say we don't get answers to the questions, what that means is that we are where we were before, which is that the 3-month gap is in place. It is in place via legislation, and so we can continue to rely upon that. And in relation to voluntary overtime, it means that we don't have a case which says one way or the other whether voluntary overtime is specifically included or excluded from the calculation of holiday pay. But my view has always been that if that overtime is normal, it doesn't matter whether it is voluntary or compulsory, it is simply normal, and therefore it should be included in the calculations. The Steer and Stormshaw case, now this is a case which, again, I've spoken about on previous updates and could have had a really significant effect on discrimination claims, because it was all about interim relief and whether a claimant could bring a claim of interim relief, which would mean that they could potentially be reinstated into their job, having brought their claim pending the outcome of the claim, which of course, given that the delays in the tribunal system are quite significant. And in fact, I had a preliminary hearing for a case just last week, and that was listed for a full main hearing in November 2020. So 18 months away, which is quite a delay, I think you'll agree. But anyway, essentially, the quite interesting and intriguing argument to try to obtain interim relief for those individuals who may be bringing discrimination claims has failed. So it's still restricted. Interim relief is still restricted to whistleblowing, health and safety, trade union type issues. So it's not going into the big wide world of discrimination law. So now we get into, rather than looking into the future of the cases which are going to be coming on down the line, we're now looking at what cases have been reported. Now, before I get onto that, I can see that we've had a question, which is whether we can ask. It's going back to the vaccination point and going back to the COVID issue about whether we can ask an employee whether they have had a vaccination or not. Well, I mean, we can ask, but what are we going to do with that information? Because if they tell us that they haven't had the vaccination, then yes, we can encourage them to go and have the vaccination. But other than that, there is very little that we can do. If they tell us that they have had the vaccination, then I suppose all well and good. But it's not that we can't ask the question, we can, but it's really what we do with the information, because it's really rather limited indeed. So I hope that answers that question. Now, fire and rehire. So of course I mentioned this when we were having a look at the Queen's speech and the fact that we were expecting the government to be proposing some steps to be dealing with fire and rehire tactics for employees. And as I said, I referenced Tesco have been using this, but probably the most high profile and most wide-ranging use of fire and rehire of late has been by British Gas, who have hired and refired a number of thousands of their employees, which has resulted in losses of wages as a result of them being on these new contracts of between £4,000 and £19,000 a year. Now, so we've got two cases that deal with this, and actually one of them is semi-COVID related as well. So the first one relates to Tesco, and this is a distribution centre that is in Scotland, in Livingston in Scotland, and what this case dealt with was essentially the challenge. Excuse me, I do apologise. So it's a challenge by the trade union. So essentially, the trade union, USDAW, were bringing an injunction, which is essentially an action that you can bring in court to get someone to stop doing something. And so they brought an injunctive claim to prevent Tesco from hiring and rehiring their workers under new contracts and under new contractual terms, and they succeeded in doing so. Now, that was in relation to their site in Livingston. They are also trying to bring injunctive claims in at other distribution centres where Tesco are doing using the same tactics in relation to their workers in England. So I haven't seen any published outcome of any of those other attempts. So it's interesting to see the approach that the unions are beginning to take to this. So because as you can see here, the statistic, 1 in 10 workers have reportedly been fired and rehired on less beneficial contracts during the pandemic. Now, of course, one of the reasons why employers do this is because, for example, in the pandemic, perhaps there has been a reduction in the amount of income, and as a result of that reduction in income, they can't carry the overheads, the contractual costs that they are committed to, including those of their employees. But it could be that whilst that they do have that impact, there might not actually be a reduced requirement for them to employ people. And so it might be that they're just simply having to restructure their business, but still have the same number of employees. And if you still have the same number of employees, and you still need the same number of employees, then you can't go into a redundancy situation. So the only way that you can really do that is by going into a fire and rehire situation. Now, obviously, you've got to show that that is fair and reasonable for you to do so, because, of course, if you go into a fire and rehire situation, one of the potential consequences, of course, is that somebody doesn't sign a new contract, in which case you have potentially dismissed them. I say potentially dismissed them, you will have dismissed them. And so you've got to show that that dismissal is fair. Now, we then turn to another case, and as I said, this is one that focuses in on COVID issues. So this involves a law firm. So Miss Cartoon was an experienced personal injury solicitor dealing with car accident claims. Now, of course, one of the impacts of the COVID pandemic was that, of course, we were all encouraged to stay at home, and so therefore we weren't driving around in our cars so much. And as a direct consequence of all of that, the number of accidents that were occurring were greatly reduced, and so therefore the number of injuries were greatly reduced, and so therefore the number of personal injury claims were therefore greatly reduced. And so for Wynn solicitors, as soon as the lockdown was put in place, they realized that there would be a reduction, a significant reduction in the amount of work that they were receiving. And so in order to try to manage that, they then put 50% of their staff on furlough from the 30th of March. And then anyone who wasn't on furlough would then be required to agree to a reduction in salary or in hours, equating to a reduction of 20%. So essentially meaning that everyone would effectively be taking the same hit in their salary, albeit, of course, I accept that we've got caps in relation to the furlough payments that are made. Now, the most experienced staff, including Ms. Coutan, were then, they weren't placed on furlough because effectively what the solicitor's firm was experiencing was that they didn't have the drop off in work quite yet. And so they were effectively doubling the workload for those who were remaining, and so they needed their most experienced and best able and best performing lawyers to remain. And those employees that weren't put on furlough, they weren't offered furlough, were told that if they didn't agree to these amended terms, they would be immediately dismissed. So, unsurprisingly, she wasn't very happy about this, because after all, and as explained by her manager in one of the emails, double or triple the graft for the same cash as those watching Netflix in the garden is a very bitter pill. So it's unsurprising, really, from just simply from an employee relations point of view, that Miss Kutan and others would be rather unhappy with this arrangement. So even if, and obviously a number of people clearly did agree to these terms, but it was clear that in terms of the employee engagement, the psychological contract with these employees, that they are really putting that into jeopardy as a result of their approach. So Ms. Kutan obviously did not re-engage, or should I say, sorry, to correct that, she refused to sign the pay cut. She did offer some flexibility around it, so she wasn't being unreasonable in any way in terms of the position that she was taking. In fact, she was being incredibly reasonable, I would suggest, particularly given the actions of her employer in this regard. And so as a consequence of that, because she didn't agree to it, she was dismissed. Clearly, she was successful with her claim as a result. Now, just to sort of put this into the context of really what we should be doing in these circumstances. So it's obviously, I'm sure you will all be aware that if you're changing contracts, then one of the easiest way, I say easiest, the safest way to change your contract is by getting agreement. However, in the absence of getting that agreement, you can do it by dismissal and re-engagement, or fire and rehire, as the more common phrase is. And then if somebody then doesn't re-engage, then you need to be able to show that that dismissal is still fair for SOSR, which is the some other substantial reason. So you've got a genuine business and significant business reason for having to go through this process. However, there is still also in the background to all of this, there is still the risk of this relatively old case of Hogg and Dover College, where in fact, in that case, we had a situation where Mr. Hogg did re-engage, but he still claimed that the original dismissal from his original contract was an unfair dismissal, and that he simply accepted the new contract in mitigation of his loss. And when I say in mitigation of his loss, in order to, it's reasonable for him to accept the new contract to reduce the losses that he would be suffering if he were to refuse it, and therefore not have any work at all. And he then sued for unfair dismissal for the losses between the old contract and the new contract, and was successful with it. And so we need to be aware of the fact that even in circumstances where perhaps somebody does re-engage under the new contract, there is still risk there. And so we need to ensure that whenever we're going through a dismissal and re-engagement or fire and rehire process, that we are doing so in an appropriate, fair and reasonable way. And of course, if we are proposing to fire and rehire 20 or more employees, we've also got collective consultation obligations to comply with as well, which I haven't addressed here in terms of giving you a rundown of your collective consultation obligations, but just to make you aware that that is also sitting in the background to all of this. Now we get on to quite a controversial case. Now just excuse me a moment while I take a little drink, because it is very warm today. Now, this is the Forstater case. Now, this has received quite a lot of publicity and is quite controversial. So let me just explain to you what this is all about. So first of all, what the courts were grappling with here is whether a belief that gender is indisputable, is immutable, whether that belief is a protective belief under equality. Now, just to explain, so The claimant, so Miss Forstater, contended that her belief that gender was indisputable amounted to a protected belief. Now, she worked as a visiting fellow at the Centre for Global Development between 2015 and 2018. And during that time, she was a regular on Twitter. And as you can see here from one of the tweets, and this was the tweet that got most attention, and in fact was also retweeted by J.K. Rowling, hence its quite broad coverage across social media. So as you can see here, she's saying that I share the concerns of Fair Play Women that radically expanding the legal definition of women so that it can include both males and females makes it a meaningless concept and will undermine women's rights and protections for vulnerable women and girls. Some transgender people have cosmetic surgery, but most retain their birth genitals. Everyone's equality and safety should be protected, but women's and girls lose out on privacy, safety, and fairness if males are allowed into changing rooms, dormitories, prisons, and sports teams. And so, obviously, this is quite a controversial area. And it's also an area of obvious conflict because, of course, what the Equality Act also does is it protects any trans individual from being offended. So harassment, Section 26 of the Equality Act, protects any trans person from being treated in a way that that degrades or humiliates them. And of course, this potentially could do so. This is where we get the conflict between protected characteristics, as of course we've previously had with religion and sexual orientation. So in that respect, it isn't new to have conflict under protected characteristics, but it is this is the first case that's dealing with the conflict between gender identity and this belief that gender is immutable. Now, just going back a slide to just give you a rundown of what the test is here. So the test of whether a belief is protected or not was set out in the case of Granger and Nicholson. As you can see, there's five tests here. It's the last one that we're focusing in on here. So it's about whether a belief is worthy of respect in a democratic society. That is to say that it must not be incompatible with human dignity and not conflict with the fundamental right of others. And so this is the issue that the tribunal was grappling with. Now, they also had to, as you can see here, we're talking about the Granger case. There's also a number of other pieces of guidance and particularly the European Convention in relation to freedom of speech and the right to freedom of thought, conscience, and religion. And that becomes particularly relevant in a moment as I move on to that. Now, the Employment Tribunal decision rejected her complaint. So the tribunal concluded that Ms. Forstater met 4 of those 5 criteria that we've set out there in the Granger and Nicholson case, but it did fail on the last one. So the final criteria relating to the respect of a belief in a democratic society. So they said that her belief that sex was immutable, the resulting conflict of that with the rights of trans individuals meant that her belief was incompatible with human dignity because it was offensive, or at least offensive to those people. Now, there are other similar cases. So we've got this Makareth case where a Christian doctor's belief that God only created male and females, that a person cannot choose their gender. He had a lack of belief also that an individual can be trans, and therefore he raised conscientious objections to the concept of trans people and refused to treat, well, not refused to treat, sorry, I'm going a little bit further than was the case, refused to address trans patients by their preferred pronouns. And so again, the Employment Tribunal concluded that wasn't a belief that was protected. And we've got this case, the Higgs and Farmer School. So Mrs. Higgs had a lack of belief in gender fluidity. Now this one went the other way. So in terms of the decision, so they said that Mrs. Higgs's views were not incompatible with human dignity. So you can see there's a general flux here, general uncertainty. Some tribunals were saying that it was incompatible with human dignity. That is the belief that either a lack of belief in gender fluidity or a positive belief that sex is immutable. So we needed some certainty. So the Forstater case is the first one that has gone up to the Employment Appeal Tribunal. And essentially what they have said is that, well, as you can see, so freedom of expression is one of the essential foundations of a democratic society. And it can only exist with tolerance and broad-mindedness. The court should not inquire into the validity of the belief, and that the state should remain neutral as regard to competing beliefs to ensure that opposed groups tolerate one another. And so on that basis, they concluded that it was a protected belief that was worthy of respect, essentially saying that beliefs can be protected, and only those that are really very extreme and very offensive, such as a belief that that the Nazis were right, and it's those kinds of beliefs that will not be protected. Now, in terms of what happens now, of course, what all this has done is it's shown that Mrs. Forstater has got a belief that could be protected, but it doesn't necessarily follow that the non-renewal of her contract by GCD Europe was in fact as a result of her belief, or was it because of the way in which she manifested that belief? Okay, so this is where we're having a look at causation. So it doesn't necessarily follow that employers cannot take action. So we need to keep an eye on this case and have a look at the rationale that's going to come out from the Employment Tribunal in terms of the way that they address the issue in relation to the manifestation of belief. And of course, we need to ensure what this case doesn't do is it doesn't say that people are allowed to say things that are offensive to trans people, because of course trans people have protection under the Equality Act. Clearly they have protection under the under the Equality Act. And so we need to be ensuring that we're taking steps to control behaviours and the expression of beliefs, the manifestation of beliefs within the workplace, to make sure that one group isn't offending the other, in the same way that we will have done with religion and sexual orientation. And we are allowed to intervene when the manifestation of those beliefs are in a way that is going to be offensive to another group, if we've set very clear rules and boundaries around that. So it doesn't mean that we can't manage this situation. It just simply means that this is another area where, as an employer, we do have to be somewhat careful, but we just need to be very clear with our employees what our expectations are. Now I'm conscious of time, so I'm going to leave you with this. It's just simply a very narrow case that also deals with whether self-employed individuals, this is Deliveroo, whether they were workers or not for the purposes of collective bargaining. This case did conclude that these people weren't workers, these Deliveroo individuals weren't workers, but it's quite a narrow decision. It deals with collective bargaining rather than, and European convention law, rather than necessarily the Uber case. So it didn't specifically refer to the Uber case. So take this one with a pinch of salt, but I just thought I'd let you know that it exists. And I've got a couple more cases that I just want to go through very quickly. So the first one is, again, another COVID related case. So this deals with an employment tribunal level decision, and it's where an employee was automatically unfairly dismissed when his employer dismissed him for failing to follow company procedures for taking unauthorized holiday. Essentially what happened, it was the beginning of the pandemic. He went on holiday to Italy and then couldn't return, or at least he refused to return because he considered that he was in danger if he were to try to travel back from Italy to the UK. He took steps to protect himself from that danger, i.e. staying in Italy. And so therefore, as a result, because of the serious and imminent danger that he was exposed to, that and it was reasonable for him to take those steps to protect himself from that danger, that therefore the subsequent dismissal was automatically unfair. Now, the final case that I'm going to talk about today, and I know that we've only got 5 minutes left, so I won't rush it, but I won't dwell on it too much either. So this is the Dobson and Northumbria Integrated Care NHS Foundation Trust. I do love a good NHS trust name, case name, because it's always nice and long. So this deals, I mean, this is actually really quite straightforward, because this deals with the issue of childcare disparity. So the principle that women are less likely to be able to accommodate certain working patterns because women bear the greater burden of childcare responsibility than men. The facts of this case are that there was a restructure of the working hours, which as a result included weekends. Mrs. Dobson wasn't able to comply with that because she had 3 children, 2 of which were disabled, and as a result of that, she then rejected the offer to be re-engaged under new terms. So this is the whole dismissal and re-engagement that we were talking about earlier. So that's the process that the NHS Trust was going through. She didn't re-engage, and so therefore she was dismissed as a result. Now that is potentially an issue of indirect discrimination. So I won't do the full summary of what the law in relation to indirect sex discrimination is. You can see it in the slide, and the pack will be out to you later. But essentially it means that where you have a provision, criteria or practice that puts a particular group at a disadvantage, then that will be indirect discrimination unless the organisation can then show us a proportionate means of achieving a legitimate aim. And the decision of the Employment Tribunal in the first instance, don't worry, we get on to the EAT in a moment, was that there was no evidence to support the argument that PCP, i.e. the requirement to work these new flexible hours, which included weekends, put women at a particular disadvantage to men. And in coming to that conclusion, they also had a look at the fact that the team in which Mrs. Dobson was in, every other member of that team, be they women or be they the one man, were able to meet that requirement. But what the Employment Tribunal said was that no, you shouldn't have just been looking at the team that Mrs. Dobson was in. It's a much broader group that you should have been looking at in terms of whether people were able to generally comply with this requirement. But also the tribunal had erred in finding that there was no evidence that women were put at a particular disadvantage as a result of this. Because whilst there wasn't specific evidence that was brought before them to show that women were at a disadvantage as a result of childcare responsibilities when it comes to flexible hours of work, or should I say more uncommon working hours, that what the tribunal should have done is it should have taken into account of what's called judicial notice. So that's the fact that it's generally known and accepted that women are less able to comply, and so therefore there isn't a requirement for evidence to be produced of this. And in respect of the cases that have previously dealt with this, they referred to a number of cases, which of course, as you can see over the years, and we've also got quite recent cases in there. So it's from 1999 all the way up to 2019. And whilst this disparity is decreasing as societal norms change and amend, and as more men do get involved in having childcare responsibilities, so it's not denying the fact that it isn't changing, but it's still not at a stage where women are not, as a group, disadvantaged in comparison to men. And so therefore she was successful with her claim. And that really concludes our case. I've got another case here which I'm not going to talk to you about. It will be in your pack. You can have a look at the slides when it comes through. There is a new right for workers in relation to protection for health and safety matters. This again has been introduced obviously because of the COVID pandemic. Previously, this right was only for employees. It's now been extended to workers as well. Don't forget, of course, IR35 came in on the 6th of April. That's furlough ends at the end of September, and there has been an extension in gender pay gap reporting until the 5th of November, but don't forget that that needs to be done. So pretty much on cue. It's 1 o'clock. I appreciate you've probably all got other calls to get on to or a lunch break to have. So I hope that you have found that useful. Please do get in touch if there is anything that we can do for you. Those are my contact details. I'll leave them on the screen for a moment. I will, of course, be sending out the packs to you. And if you want to have a chat about anything that we've covered here, got any other questions, or just need advice about anything at all, or of course, if you'd like to know about any of the packages that we can do to support employers, and we can do those on annual fixed price basis as well, then please do get in touch. I hope you found that useful. Hope you found it relatively enjoyable as employment law and HR updates can be. And have a good rest of the day. And no doubt, see you at one of these updates again very soon. All right. Thanks very much.